Is the law a determinate system that will give you a definite outcome as long as all parties are unbiased? Is this the correct way to think about the law, or is the law, in fact, inherently political? That's what we're going to talk about today with John Hasnas, who is Associate Professor of Business at Georgetown's McDonough School of Business. He's also a visiting Associate Professor of Law at Georgetown University Law Center in Washington, D.C. He's the author of Trapped: When Acting Ethically is Against the Law. We're going to be linking in the show notes to several of his important articles, including the canonical one, The Myth of the Rule of Law, that we'll be discussing today. John Hasnas, welcome to the program.
Thank you for having me.
Some years ago, I read your article, The Myth of the Rule of Law. And let me tell you, I emphatically and indignantly rejected the thesis of this article. I could not accept it. And I think, judging from the tone of the article, that's the response you were expecting from a lot of people. But I was somebody who was already more or less a libertarian, and yet I thought what you were saying was so out of bounds, even though I couldn't refute it, and it ate away at me for years until finally I said, all right, that Hasnas is right after all. So I want other people to have their eyes open the same way that mine were. So let's start off by having you explain the myth of the rule of law, that is to say, what it is that people think of when they hear this very attractive-sounding phrase, the rule of law.
Okay, I'll try to do that, but you are asking me about an article that now is quite old, so I'll do my best to recall it and reconstruct it. I have to say, I appreciate your reaction. I find that with regard to my work, if someone agrees with me in less than 2 years, I know they're not thinking about it very deeply.
Okay, well, thanks.
The article, The Myth of the Rule of Law, it does require a little bit of clarification. There's a widespread belief in the philosophical community, and I believe it also reflected in the general community, that the outcome of legal cases is controlled entirely by the language of the rules of law. The idea is that somehow it's the law that's determining the outcome, and that this is a neutral and objective set of rules that determine an outcome, and that there is one right answer, and this is not a matter of one group of people controlling the behavior of others. Now, there's a lot of ways in which the rule of law is used that have other meanings, but that's the one that the article's about. It's a very, very widespread belief. The argument is when it's human beings making the law, it's the human beings that control and not the rules themselves. And the article tries to illustrate this with many examples. The example I use that's most common is the First Amendment to the Constitution. The language of the First Amendment says, Congress shall make no law abridging freedom of speech and of the press. If it was the language of the rule there that was controlling outcomes, then almost everything that people believe and would produce much different results than what we usually get. For instance, if I ask most people whether the Congress can pass a law prohibiting someone revealing military secrets in the time of war, they'll say yes. But that means that they're interpreting the word no to mean some. Does the First Amendment prohibit flag burning? A lot of people will say it shouldn't, but then you're interpreting the action of burning a flag as speech or press. Every single word in the phrase is interpreted on the basis of pre-existing political beliefs or ethical beliefs that the speaker already has. As a libertarian, I will interpret the First Amendment to create the greatest possible protection for freedom of speech that I can imagine. On the other hand, people who disagree with me, for instance, people who are advocates of campaign finance reform and think that rich people shouldn't have the ability to spend a lot of money to articulate their political positions, who read the same language and come up with an entirely different conclusion. It's not the words that are controlling things. It's the presuppositions of the individuals who are in the position of making the decisions. With regard to constitutional law, that can be the Supreme Court. With regard to ordinary state-level law, it can often be common law courts. But as long as it's human beings, it's always the rule of some people over others. It's never the rule of some objective, impersonal law that somehow exists out there.
Now, what I like about this First Amendment example is you're saying that if we take a statement that we're all familiar with, the First Amendment, text words that we're all very familiar with, and whose meaning we all think we know, and then we note just how broadly it's interpreted by so many people in ways that clearly depart from that text. Well, if the First Amendment, which is a canonical statement, can be interpreted in such varying ways, then what hope have we for just the ordinary case? For instance, in the article you give numerous examples in which you are disputing the claim that every time there's a legal dispute, there is, at least according to the myth of the rule of law anyway, a single determinate outcome that is demanded by words on a page. I recall one of the examples having to do with somebody having something that was of indeterminate worth. He didn't know how much it was worth, so he sold it for $100. And then it turned out to be an item of priceless value, and so he sued to invalidate the contract. And it turns out that even a matter like this, where there would be a law of how to deal with situations like that, you can still find precedents that would go both ways in a case like that.
At least part of the article that you're referring to is one that was written and would be familiar to almost anybody who's taken a first-year law school course. There's a rule of law that is fairly well known to first-year contract students, and that's the rule that says when two parties to a contract are both mistaken as to what some essential element of the subject they're negotiating about is, the contract's rescindable. It's not a valid contract. That's called the rule of mutual mistake. The question is, when are both parties mistaken about something? There's two different cases out there. One is a case where a woman finds an interesting rock, brings it to a dealer. It's actually a rough diamond. Neither party knows what it is. She sells it as a rock of unknown quality. Later it turns out to be a rough diamond, so she wants to rescind the contract and get it back. And the answer is, there's no mistake. Both parties knew it was a rock of unknown value. No mistake. To apply the rule directly, it says the contract is not rescindable. Then there's another case about a picture purchased at auction. It turns out to be for $100. It turns out to be a lost masterpiece worth much, much more. There's a suit to rescind the contract. In this case, the court finds that there is mutual mistake about the subject of the contract because both parties thought it was some cheap work, so the contract's rescindable. Now, what matters here is not the language of the law. What matters here usually is whether the decision maker thinks it's going to be a fair result to uphold the contract or not. In our legal system, there are always enough precedents so that you can find a good argument for the conclusion that you think is just. This is not that someone's out there manipulating things for some kind of nefarious purposes. Most judges, most decision makers want to do what they think is just and right. And we have enough precedents in our law that will allow them to find an argument for that result. So the rules are not controlling anything. What controls things is the beliefs about justice of the people in the role of making decisions. The article I wrote is to say there's only two options. One is you're going to have to control the people making the decision if you want the law to come out your way, or try to remove as much as you possibly can from the realm of the law and leave it in the realm of private decision-making.
So in other words, you're saying that the reason that court decisions are not completely random or completely unpredictable is not that there's the rule of law keeping them semi-determinate or predictable, but that probably the judges have at least some ballpark resemblance in their visions of what is just, and that's what drives whatever stability we see in the law. Is that what you're claiming?
That's a great statement. That's very well put. That is what I'm claiming. When someone says that the rule of law is a myth or that the law is indeterminate, what that person is saying is that the rules are not controlling things. Something else is. But that doesn't mean that you can get any decision from a legal case. It's perfectly predictable based on what the people in the decision-making role share. If we pick almost all of our judges from rich Bostonian Harvard graduates, and they all have a common background, you can bet that the outcome of cases will be predictable and will be fairly uniform. A big complaint in the last few decades has been that the law is becoming scattershot and it's becoming more and more unpredictable. Well, that corresponds to a time period in which we're trying to diversify the bench, where we get people as judges from different backgrounds, different socioeconomic classes. The diversity movement in background also makes it less likely that the judges will share the same predispositions, and the law becomes less predictable. But even within that realm, in our system, to get to be a judge, you have to have a fairly conventional range of opinions. Someone like me, who writes articles like the one you read, you know for sure I will never be a judge. I'm too far outside the range of what's conventionally acceptable. But that's what controls the common belief structure of people in the decision-making capacity.